And we're thrilled to present on this topic, very much requested topic of probate planning. We're going to probably take no longer than an hour. The presentation itself will probably be around 40 minutes, and then we want to allow some time for Q&A at the end. We'll do our best to address everything, but we'll also contact you afterwards if there are specific questions that need a little bit more discussion to actually answer. So I just want to share with you here a quick agenda of what we're going to be working through today. We'll do some introductions so you can get to know myself and Sophia, as well as ClearEstate if you're not already familiar with what we do. We're going to do an overview of probate, of course, start with a sort of explanation of what probate is all about. And then we're going to talk about some common probate planning strategies, as well as the important considerations for those, and highlight some key takeaways for you today, and then, of course, go into the Q&A section. So real quick, just a little bit about me for those of you who don't know me. I have many years of experience in the estate and trust field, working on both estate planning as well as estate settlement. And my goal is to always break things down into a more digestible manner, which is a bit of our mission at ClearEstate for sure. And we really want to help families with sensitive and practical guidance. Sophia, my co-host, I'll give you a sec to introduce yourself, Sophia.
Hi, everyone. Thank you for joining. I've been in the estates world for over a decade, and like Sarah, we're really passionate about this area. I actually got into it because, like many people, we've seen families, couples, children fight over assets and the fine china, etc. That's actually what attracted me initially, because I saw family members and friends going through this process. That was about 15 years ago. So, and then eventually got into the estate settlement side, which is a more empathetic and patient side, because you're trying to help someone who's grieving settle the estate of their loved one. So I'm super excited to be here, and back to you, Sarah.
Thanks, Sophia. And I don't know that it's really the fine china that people are fighting about anymore. It's more.
Yeah, I don't think so.
Yeah, probably more other assets like Bitcoin. But yes. Yeah, it's definitely common that it's difficult to move through an estate settlement smoothly, for sure. So just a little bit real quick about ClearEstate. These are our founders. ClearEstate was founded in Montreal. We are now actually servicing multiple jurisdictions across North America. And it all started when Alex, one of our co-founders, was actually faced with dealing with his own mom's estate. And he really found that the processes involved were antiquated. He was overwhelmed. It was very challenging for him to be able to get the support he felt that he needed with the process, and that it really wasn't very modern approach of dealing with things. So he put his sort of product thinking cap on and came up with a solution to solve for this very real problem, and assembled a team of engineers combined with subject matter experts to create ClearEstate, where we're setting out to literally change the way estates are settled, by supporting families with all aspects of estate planning and estate settlement, and doing that in a simplified, modernized way through the platform that we have developed. And in terms of what you're going to be learning today, definitely, as I mentioned, we're going to talk about when, why, and how probate applies, which is really important to actually understand before you can go about actually strategizing around probate. And then, of course, we're going to talk about actual strategies, ways to reduce or avoid probate. And then, of course, we do want to chat a little bit about seeking out professional guidance with these topics as well. Now, diving right in, and I'm going to say too, we got a ton of questions in advance around defining probate. So I hope through these next few slides, those questions will naturally be answered, as I'm going to try to give you a concise explanation of what probate actually is and what's involved. Okay, so a clear and simple definition here is probate is the judicial process where the will, if there actually is a will, is validated, as well as the estate representative's authority is legally verified by the court. Now, lots of people have questions about, okay, if I have a will, do I need probate, or why do I need probate if I have a will? And the answer is you may need both, right? You may need you realistically, you need a will no matter what, because you want to appoint a executor of your estate to actually represent your estate, and you want to decide how your assets should be distributed, right? But probate becomes a question of when your executor goes to deal with your assets in your estate, they're going to deal with third parties. What are the third parties going to require in order for them to accept instructions from the executor, right? So really, it's proof for the estate representative to go and then actually provide that to financial institutions, to the land titles registry, et cetera, to actually be able to say, okay, this is what you need to do with that asset. You need to transfer it accordingly. Okay. And I think the bottom line is that the third parties don't want to be responsible for determining whether they should release the funds to this person or this person or that person. They want the protection that probate provides them, that they're dealing with the correct person and they're distributing the funds accordingly. Okay. Now, Sophia, in your experience, do you find that a lot of folks maybe are sort of not familiar with probate? Like if you're starting an estate planning process, is probate kind of something that people don't really necessarily fully understand?
Yeah, absolutely. I think it often sounds like this imaginary word or scary word, that like, what does that really mean? And probate really is a nickname that we use for certificate of appointment of estate trustee. It's literally a pretty certificate from court that states who the executor is, and if there's a will, the will is attached to that certificate. And that is what allows the executor to go, like Sarah said, like go to an institution, just say the deceased had an account at National Bank, to then be like, okay, here's a certificate, now I have the authority. And I've had people say to me, well, if I get a will, I don't need to go to probate. Well, as Sarah answered, that's not necessarily true. I've had people say, if I don't have a will, the government's going to take all my money. Also not true. So definitely lots of misconceptions over probate. When can probate be avoided? How to avoid probate? And how long does it take? And of course, somebody always has a horror story to share. And often those horror stories are usually because estate planning wasn't done well, regardless if there's a will or there isn't a will.
Yeah, absolutely. And I guess one of the things to really clarify is, is probate necessary in all circumstances? That's a big question that we get a lot, and definitely we're going to go into some specifics. But Sophia, if you could just answer, generally speaking, is it always necessary?
Not always. So excuse me for a second. By the way, I apologize to the attendees in advance. I'm getting better from a cold, so I might take a break here and there. So probate's not always needed. So a perfect example, I'm married, I have a spouse, most of our assets are joint. So when I pass away, those joint assets are going to pass to my spouse automatically. Probate's not needed. Nobody's asking for that authority because everything was jointly held. There are also other exceptions. I don't want to get into right away, but there's a real estate exception. Yeah. So mostly real estate, probate's needed, but there are small exceptions where it might not be needed. And there can also be other exceptions where the money in the bank account, for example, is, say everything else was joint, but there's a account with $5,000 in it, and the deceased had a very good relationship with the bank. The bank has looked at their liability and is willing to waive the requirement for probate, and is willing to release it. It doesn't happen as much now in my experience, but I think back in the day when people had relationships with the bank and the bank manager and the bank teller, it was a little bit more prominent. But yes, there are times where probate is not needed.
Yeah, absolutely. And actually, Sophia, I'm really glad you brought that up, because I did want to mention that, most of what we're talking about here in this session is really around what you're doing ahead of time. But an excellent point, something that an executor can actually do when the time comes is simply ask the bank to waive the requirement for probate, right? A lot of people aren't actually aware of that. Now, like you said, it may not fly, it may not actually work. However, the bank won't recommend that you ask, right? Like the bank won't bring it up as a suggestion for you to do it. But they will consider it if you ask, right? And every financial institution has its own, internal processes and procedures for dealing with that. And they may say no, but you don't know unless you ask. And of course, the smaller the value of the account, the more likely they could do that. And Sophia, as you said, if they actually know the deceased as well as the personal representative of the estate, that's helpful. Okay, a couple of other things to note, and I think most of the attendees here today, if not all the attendees, are from Ontario, so we really are talking, some Ontario specifics here. Some of the sort of downsides of probate is, of course, that it can take several weeks to months, and most jurisdictions impose some type of probate fee. So in Ontario, properly called a state administration tax, it's calculated as described here, $15 for every $1,000 above $50,000 of the estate's value. Okay, and there's an example here to show you how much that calculates to. There's no cap to the probate fees, so it really does. It really does can be significant depending on the value of the estate, and is a very compelling reason for people to think about it in advance and perhaps consider some ways to potentially avoid probate. Now, I think in terms of the courts, and we talk a little bit about the process. Sophia, if you could maybe just in your experience, like what would be like a typical timeline in terms of, I mean, I think there's a flurry of activity in the beginning to kind of like for the executor to get the information they need, assess the value of the estate, and hopefully they've sought the right guidance and are able to prepare the probate application, quickly, because they can't move forward with dealing with those third parties until they have the probate application granted. But in your experience, how does the timelines work with the courts?
So, like you said, Sarah, there's this preliminary work before the probate application is submitted, where you're gathering information on the value of the assets of the deceased. And then the application is prepared and it's submitted. And once it's submitted, it's really out of the hands of, it's really out of anyone's hands. It's in the court's hands, really, to grant when that takes place. And it really varies. So in Ontario, we have really busy cities like Toronto, and then we have smaller cities, and really you're submitting the application on where the deceased resided right before death. So if the deceased didn't live in Ontario and they had an asset here, then you would submit to the courthouse of where that asset is. But generally, you think of like, I live here, I live in Toronto, when I pass away, it'll be submitted to Toronto court. So there are definitely courthouses that take longer. I think if you call the courthouse, they generally say 6 weeks to 4 months. In my practical experience, I would say Toronto is more like 4 months to 8 months. And then there are other courthouses that definitely can do it in a shorter period of time. I would say 6 weeks is probably the shortest period of time.
Okay, wonderful. Thanks, Sophia. I think that's the second piece of, a significant reason why people do probate planning or think about probate planning is, of course, not just the expense, but also, the fact that their loved ones have to go through this process, and that it's not easy to navigate, and it takes a long time to complete before they can actually take real action in your estate settlement.
And Sarah, sorry, just jumping in again and just touching on that point. And when you think of real estate and you're thinking of, okay, my deceased has passed away, my loved one has passed away, sorry. There's this house that's sitting in Toronto that needs to be sold. You can't actually sell it. Like the closing can't take place until probate's granted. Well, if probate, from beginning to end takes, say, 8 months, that's a long time. While expenses still need to be paid for the home. So not to say like you have to avoid probate, but it's just something to keep in mind and ensure that you have funds aside so that during the time before the home could be sold, there's enough money there.
Yeah, absolutely. Great points. Great points. And I think actually we're going to do a quick poll to see if everyone's paying attention. But it's because one of our big goals is, of course, demystifying all the elements of estate settlement. We just want to do a quick poll right now. So I think Carrie will be putting up a poll here for how many of you feel that you have a good grasp on what probate actually is and is all about. So that should come up on your screen momentarily, and you can actually answer yes, no, or not sure still. I'll give everyone a minute to just answer the poll. Okay, perfect. So we have kind of a split result. 54% of you feel you're pretty good. You have a good grasp on what probate is. 18% are still unsure, understandable. And 28% are not sure if they're have a good grasp on it or not. You guys, this is pretty consistent with what we find. It is difficult to understand the concept of probate until you practically apply it to your individual circumstances. I would encourage you all to consider further reflecting on your estate plan after this, and we can also we're available to you to chat about your specific circumstances as well. So thank you for that, Carrie. Now I do want to, this is sort of a bit of a disclaimer that kind of is in line with the poll we just shared, but essentially we're going to talk about some strategies to avoid probate, but I want to, give this as a disclaimer in advance where we're not giving you advice on your specific circumstances. And it's really important that when we think about probate planning, that we actually think about it as part of our overall estate plan and not just in isolation. Because when we think about one component of estate planning in isolation, this is where we may solve one problem, but create 6 more, right? On a different aspect of things. We do actually have some different webinars that we do. We do a bit of a series of webinars on different topics, including the probate, estate planning basics, et cetera, et cetera. So, I would, we can send additional links to you so that if you want to do a bit more discovery and information research on the topics, you can dive in a bit deeper. But again, you got to look at your whole circumstances in order to understand which of these strategies, if any, is actually right for you, and consider, of course, professional guidance to help understand what's going on. And the last thing that is very often overlooked when implementing probate planning strategies is you should consult with the third parties who will actually be involved when the time comes. For example, if you implement a probate planning strategy that you believe will save your bank account from needing probate when you pass away, you should actually confirm that with the bank in order to get ahead of any potential problems with that. And then the other thing I do want to mention is that probate is often viewed as this sort of evil process that is implemented just to torture families, right? And while it is not an easy process to navigate, there is a purpose behind that. And I know we kind of explained that, it does have protective purposes. One of the important protections it provides is not just for the third parties, but it's for the executor themselves as well. Because once the executor has obtained probate, they can now proceed with distributions under the will, free from any worry that in future they're going to be held accountable for having made incorrect distributions, right? Because they've confirmed with the court that the will is legally valid and that they're authorized to deal with the estate, okay? So it's important to keep that in mind too. There is a purpose behind it too. Okay, so strategy number one, which is probably the simplest strategy that you could potentially implement, inter-vivos gifting. What does that mean? Inter-vivos gifts refer to a gift or a transfer to someone while both parties are still alive, okay? The pros of this, or the way that this essentially accomplishes probate avoidance, is that you've effectively transferred or given the asset during your lifetime, and it's no longer in your estate when you pass away. So it's actually a very simple concept. Sophia, what do you think might be some maybe concerns with this?
So, I think I really appreciate when people do gifting during their lifetime for things like, jewelry, for example. Like I once had a client, 90 years old, she had accumulated beautiful pieces over time, and she decided that while she's alive and she's not wearing it anymore, she will distribute, or she'll give it as a gift to her children, her grandchildren, whatever loved one she wanted to give it to. And I really appreciate that. At least they can use it and she can watch them use it, and it's great. I think the concern is if you're giving away large sums of money. So, for example, I'll use my example. I'm 90 years old. I'm moving into a long-term care facility. I sell my home and I have this wealth, but I still have some other money that I know will take care of me till I die, and I anticipate I'm going to live till 100, for example. Is it a good idea to give away the rest of my wealth to my whoever, say my kids? I don't know. How about if I need that money? Like, how about if I need it, something happens? I think coming out of a pandemic, we've all seen that life can change very quickly over time. So the worry about gifting during the lifetime is that, how about if you need more and you've given it away at this point?
Yeah, absolutely, Sophia. Like, great points. The way I like to look at it is, estate planning should very much still support your needs and your goals that you have during your lifetime, right? Yeah. In fact, that should be the primary concern. And only once that is, secure and addressed, can you really start to plan, responsibly for what's next. I think, it's definitely very common consideration. And I agree that, personal effects, that's one thing, and it is a relatively simple way of doing it and guaranteeing, that it gets into the individual's hands that you desire for, to have it. Sometimes it also gets out in front of potential issues between, family members in dealing with personal effects after you've passed, right? But definitely, gifting significant amounts of your assets is a concern, because you may have calculated that you need X amount of dollars, and maybe even been conservative about that, but who knows what might happen, right? And you want to be able to use and enjoy your wealth during your lifetime for you first and foremost before considering anything else. However, like I said, it does effectively remove it from your estate, and therefore it won't be subject to probate fees. So the next strategy that we want to talk about today is joint tenancy, which Sophia, you had alluded to a little bit earlier when we were introducing the probate topic. And this is where property is owned by two or more parties, each with equal rights and obligations. Okay, and It's commonly referred to also as joint with right of survivorship. Okay. And you when you own real estate, I'm going to say it's always clear on title how the property is owned, whether it's owned joint with right of survivorship or tenants in common, which is where multiple parties each own a share of the property. And in that scenario, each individual share would form part of their estate, right? In the joint tenancy scenario, it typically does not form part of an estate until the last of the owners passes away. Okay. It's a really important distinction. And I'm going to say it's not just in the context of real estate, it's also in the context of financial accounts. Okay. Now, in Ontario, there's a presumption that, assets that are bank accounts, for example, that are owned jointly between spouses, that there's a right of survivorship. But Sophia, can you talk a little bit about what presumptions there are if accounts are owned joint with adult children, for example, which is very common?
Yeah, it's actually the exact opposite of the presumption Sarah mentioned. So we'll say a spouse, like husband and wife, have a checking account with the right of survivorship. The presumption is that husband dies, wife becomes sole owner of that account, so all the money in that account, and vice versa. But if the account is held between a parent and an adult child, the presumption is actually the funds belong to the parent in that bank account. So, how do you prove otherwise? And a lot of it's got to do with what was the intent of the bank account, whose money is actually in it, who's using it, the money coming out of it, whose expenses are being paid for it. Was there any other evidence to support that the account was meant to be truly joint, kind of like the husband and wife situation? And so a lot of parents do this, and they say they have 3 children, they add on the one child that they're maybe closest to or lives closest to them and helps them make their monthly expenses, adds that one child on. And Sarah, you could touch on this too with me, but like at the bank, you are either, sometimes you're not asked anything, or sometimes you're asked, like, what is the intent of this bank account? Is it to freeze when the parent passes away? In other words, saying that it's not truly a joint account, or is it a truly joint account? Now, sometimes parent and the adult child will say, no, this is truly a joint account. I want all the money to go to my child that I'm adding on to the account. And that might seem great at that time, but over time, I think people forget like what was done initially, what was the intent of it. And as that parent starts to sell assets, maybe in their older age, starts putting money into that account, selling, they die, the money passes to that one child as a joint owner of that bank account, but that wasn't the actual intent. And so now the other kids are, either there's going to be an argument or a fight there, or the other kids are out of luck. So there's a lot of things that can go wrong there.
Yeah, absolutely. And again, like the strategy can be effective to avoid probate, but it's important to, first of all, document the intentions clearly. And Sophia, you're absolutely right. I think financial institutions have pretty consistently struggled with actually accurately documenting the intentions behind joint accounts. And as a result, depending on where your account is and who's actually processing things when the time comes, you might actually get a different answer as to how, the account's treated, right? And the other thing too is that what I find a lot of folks may be inclined to do is, because they're implementing this probate planning strategy, and that's really the main focus, they have clearly documented that a joint account is intended to have, the surviving owner is intended to have survivorship right. And then, let's say they have 3 kids and it's their eldest child And they, not to pick on eldest children, but they end up with that responsibility. And the parent just says to them, you know, I expect you to distribute this to your siblings, right? Now you've done a couple of good things. You've managed to avoid probate, which is great. You've also managed to give some immediate access to cash, which lots of people use this strategy for. But you may have also inadvertently put, you know, a bit of a difficulty there, because the moral obligations don't actually align with the legal obligations, right? So while you expect your child to then go and share that account equally with their siblings, they legally have no obligation to, right? So this is kind of, you know, what we're talking about when we have to map out these things carefully, and make sure they make good sense with our family circumstances. Okay.
Sarah, do we have time to talk about real estate and joint tenancy? Very similar situation.
Yeah, for sure. Yeah.
So I think this is because real estate, especially in Ontario, is worth so much. Often parents will say, you know, is it worthwhile adding my adult child or adult children onto title? And yes, it might be practical to do so to minimize probate, especially on that one asset, the real estate. So you have $1 million home. But there are other considerations that have to take place. So for example, say the adult children don't live there. That's not their primary residence. They're not living with, we'll go with mom, right? So it's mom who wants to add the children. If they're not living with mom, at some point there's capital gains, there's tax considerations that will take place. And so, you know, sometimes people will ask me, like, how do I avoid probate? How do I avoid capital gains? And you can't avoid everything. So you can't have your cake and eat it too, you know. So and so people don't always weigh in on those facts. And that's why that proper estate planning is super important. Another downside about adding people onto title is you're losing ownership of your home. If the child that you've added on has debt and the creditors are coming after, you know, 50% of the home, that's their ownership. Well, you know, that did not go the way intended.
Yeah, absolutely. Great point. Or if maybe they go through a breakup, right?
Yes.
If they're married and they get a divorce, then, you know, their share of the property could be exposed to a division of net family property in their relationship. So, and these are all, you know, not necessarily thought of at the time that we're just focusing on, you know, probate planning and probate avoidance. So definitely important to look at those factors as well. I'm going to, move on to the next point here. Beneficiary designations. Okay, so this is one that probably a lot of you are already familiar with, but there are certain types of financial assets where you can actually name a designated beneficiary. These are life insurance policies, registered plans, as well as tax-free savings accounts and pensions. And these assets can really be, if you've named a designated beneficiary, then they can claim their share there of that asset upon your passing. And again, doesn't form part of your estate and therefore is not subject to probate. Okay, and I'll just note that in some circumstances, people may want their estate to be a beneficiary of certain policies, etc. So, in which case it would be subject to probate. So what we're talking about here is where you've named individuals or, you know, charitable organizations, etc., as beneficiaries directly on the plans, and they're going to receive the proceeds on your passing. And I think, you know, one thing that Sophia, if you could maybe shed a little bit of light on here is what's a sort of way that people misstep when they're doing beneficiary designations?
So there's a few things here that, you know, number one, beneficiary designations are great if that beneficiary survives you. So the intent was I want the beneficiary of my RRSPs to be my spouse, great. But I might not have thought about what happens if my spouse dies first. In that case, the RSPs form part of the estate, and then of course subject to probate tax. So people often forget about adding the alternate beneficiary. So that's one. Two, sometimes, and I've seen this, I actually have a file on my desk right now with a very similar situation. The only assets in this estate are really the RSPs where there's a beneficiary designated, TFSA where there's beneficiary designated, there's no real estate, and there's some money in a checking account. But the deceased has outstanding income tax, and then there's of course like funeral expenses and other creditors. And so the TFSA beneficiary got their money, the RSP beneficiary got their money, but there's not enough money left in the estate to pay all the other expenses. I assure you, CRA will be getting their share. So then it's a matter of, okay, well, if the deceased didn't leave enough money in the estate, where's that money coming from? Well, it's going to come from, I think everyone can guess, it's going to be clawed back from the beneficiaries of those two things.
Yeah, absolutely. And Sophia, what's interesting about that is in those circumstances, if it's not addressed carefully, CRA will just basically, they'll ultimately they'll know who benefited from the estate or from the assets.
Yeah.
And they will actually pursue the beneficiary the same way they would pursue them if they themselves had a tax liability owing to CRA. So from CRA's perspective, it's no different, even though it could have happened very much inadvertently, sort of, by accident. They may not have been the executor of the estate, and they may not have really been fully aware of, additional liabilities that weren't yet paid. So definitely that's a huge one to sort of map out carefully and think through carefully. I think another thing that I've seen is that, when we talk about contingency planning or, alternate beneficiaries, typically you can only go so far with beneficiary designations unless, you actually create a testamentary document to cover beneficiary designations. I have seen unfortunate scenarios where perhaps there was some probate planning strategies implemented maybe years ago, right? Maybe, there's a disabled beneficiary that they had wanted to account for, and they had specific trusts around that, or other concerns or other reasons that there was a sort of path in terms of the beneficiary designation. And then later on, it was kind of not really thought about, and somebody said, "Hey, you should name all your kids as direct beneficiaries of your RRSP." And so they did, but then that defeated the previous, planning strategies that they had so carefully implemented. So important to think about that and address that in the process for sure. The next one, which is pretty Ontario specific, you can actually have more than one will in your estate plan. So in terms of how that's done and why you would do that, because probably if you've never heard of it, it may seem a little bit silly, but you can actually do it in a couple of ways. One is when there's assets in different jurisdictions. If you have a property in Ontario or Canada, and you also have property in another country, for example, you can create multiple separate wills to deal with that. It has to be done very carefully so that they both work together. But one of the reasons you may actually do that is a probate planning reason, to make sure that you don't end up accidentally being subject to probate fees in two different jurisdictions for the same asset. And the other reason in Ontario is that secondary wills can also be used to address or separate assets that will require probate versus assets that will not require probate. And what I mean by that is there are certain assets that when the executor goes to deal with them, they won't be asked to produce probate, right? But once they need probate for anything, they have to include all the assets in the estate. So a secondary will is a way to have one will that you submit to the probate court and a separate will dealing with the assets that won't need probate, that then won't be subject to probate fees. And it's a relatively short list of assets, but ultimately, Sophia, if you want to just describe what the assets are that could be included in a secondary will.
Yeah, so shares in a private company. So Sarah, if it's okay, I'm going to give you like a very practical example so people understand what what we're talking about here. It's a complicated subject to process on the spot, and I often have people who get it when I explain it, and then like 2 hours later they're like, I'm not really sure if I understood it. So I'll use my example. I have a bank account, say a national bank, for $100,000. We know pretty sure National Bank is going to require probate. I don't know why I'm using National Bank. It could be any bank. And then I have shares in a company. Say I have a cleaning company, 1, 2, 3, 4 Cleaning Inc. And I'm 100% shareholder. Now, the shares in that company, it's a private company. We're not talking about stocks in Google or Microsoft, right? Those shares, nobody's asking for for probate, like proof of evidence of who the executor is, right? My executor named in the will be able to wrap up that company, sell the assets, and then the value of the proceeds will go to the beneficiary named in the will. So if I were to have 2 wills, my first will that covers all the assets where probate's going to be needed. So in my case, we're talking about the $100,000 in a bank account, and a second will that deals with all the assets that doesn't need probate. So the shares in 1, 2, 3, 4 Cleaning Inc., say my stamp collection, my jewelry, my purses. I don't have any expensive purses, but say I did,
Yeah.
right? So I can put those into the secondary will. The first will be submitted to court, and a certificate will be granted. And the executor will go to the bank and say, here, I have proof that I'm the executor now, release $100,000. And then assets in the secondary will won't have to go to probate because nobody's asking for it. Like my executor, say it's my spouse, can now go sell my stamp collection, which I also don't have, and my expensive Gucci purse, which I also don't have. But like, if I hypothetically had all these things, shares in my company and the cleaning company, like he can go do all of that and nobody's asking for it. So it saves the probate on the value of those items.
Absolutely wonderful, Sophia. That was a great example. I'll also add too that you can include any loans that are owing to you or your corporation. And you mentioned personal effects. There's also a very exceedingly rare exception where it's real estate that's never been transferred on the land title system, but that system was implemented in the 70s. So it's very rare that a property actually qualifies for that. And then finally, we're going to move on to the fifth and final strategy. Now, I'm going to preface this by saying that this is a more complex strategy that would probably mean its entirely own dedicated webinar to discuss. So we're going to try to talk about it very briefly here. But Inter-vivos trusts, which are also known as living trusts, and they're trusts that you create during your lifetime. And what you're doing is essentially removing assets from your estate, putting them in a separate trust. You're creating a document to govern those assets, as well as dictate what happens to those assets upon your passing. So again, same concept of removing the asset from your estate somehow, and therefore that's reducing or avoiding probate fees. And like I said, it is a complex strategy that needs to be considered carefully. It's not always, it's not just probate savings you're looking at. You're thinking about, okay, now what's the cost to implement the strategy? What is the ongoing administrative burden? What are the tax implications? But it is an effective strategy for probate avoidance. Okay. Sophia, did you want to add any comments regarding Inter-vivos trust strategies?
And Sarah, like you said, it's such a loaded topic, and I think it really does deserve a seminar, a webinar on its own. Yeah.
We'll have to do one.
Yeah, I think we'll just have to do one.
Yeah, exactly. Okay, perfect. Now, just to quickly cover here, like the key takeaways for you today are essentially that, probate can be reduced or avoided, but really must be planned carefully, of course, and that you need to understand the relevant considerations and the pros and cons of implementing any of these strategies. And please don't do it just because your neighbor told you that they did it and it was great. You need to actually reflect upon your individual circumstances, your estate planning goals, the ownership structure of your assets. You need to look at all of that as a complete picture in order to understand whether or not any of these strategies are appropriate for you. And of course, seek guidance in doing so. And certainly you can seek professional guidance and revisit that regularly. I'm going to take a quick minute here to talk about the way that ClearEstate supports estate planning before we dive into questions. But essentially what we do with folks is we do an intake process to gather and compile all of the pertinent information about their circumstances, as well as review their existing plan and what's involved in it, map it out in such a way that we're empowering them to understand all the components of everything, and then of course potentially create wills if wills are needed and power of attorney documents. Consider these probate avoidance strategies, as well as securely store everything in our vault that you can continue to have access to, and provide updates, etc. As well as what I'll say is maybe the most important part of it is that what you're doing is you're actually setting your loved ones up for success for when the time comes, right? And so we have everything compiled to make it as easy as possible for when that time comes. And in addition, your loved ones actually have access to our team for initial guidance to help them understand what's involved and hopefully move forward confidently in the estate settlement. This is just a little bit of a quick map of kind of the process that we go through when we're working through estate planning with our clients. And of course, our vault, which is designed to securely store all your information and documentation. It's very, easy to use and navigate, and you get the support of a dedicated estate professional to help you through all of these components. Okay. And now we are going to move to a bit of a Q&A. And like I said, I hope that some of the questions have already been addressed through the presentation itself, through Carrie in the chat. And if not, we certainly will reach out to you afterwards.
Great. Thanks, Sarah and Sophia. Thank you so much. That was great. And just before I start into some of the questions we received, I just wanted to remind everyone to watch your inboxes, because we will be sending you a link to the recording, of course. So let's start in on some questions. Can you tell us what must be included in a probate and what should not be included in probate?
It's a great question. Very, very short and very simply, if probate's needed even for one asset, everything that that person owned needs to be included part of probate, unless there was a secondary or tertiary will. And so again, just recapping, probate's needed because there's a third party asking for probate. And once probate's needed, all the assets that the deceased own, except for joint assets or assets where there's a beneficiary designated, need to be included part of probate.
Great, thank you. Move on to the next one. It's regarding wills. I recently moved to Ontario. I have a notarized will from Quebec. First, is there anything I need to know regarding the validity of the will in Ontario? Do I need to redo the same with a lawyer in Ontario, considering the extra expense for no change at all regarding my distribution of assets at death?
Yeah, Sophia, did you want to take that one?
No, you can take it.
Okay, yeah, no, I was just gonna say, so the rules and regulations for wills and estate settlement, they do vary from province to province. I would recommend you consider reviewing the circumstances. And I will say Quebec is somewhat different than Ontario for sure. So it is important that that gets looked at because yeah, the rules are different and you actually may need to redo your will depending.
Okay, great, thanks.
Mm-hmm.
Next question. I'm a resident of Ontario. I own a condo in Montreal, Toronto, and Florida. When I pass away, are probate fees and taxes payable on the deemed disposition value of all my assets as at the date of death? Or can I do something now to avoid my estate from paying any probate fees and taxes? I'm not married, although I may be in a common law relationship in the future.
Okay. Thanks, Carrie. I'll jump in there. So one thing that I want to say is there's a differentiation between taxation, income taxation, and probate taxation. There are two separate, I'll call them layers of tax. And probate fees is exclusively based on the value of your estate assets at the time of your passing. And then income taxation is going to be, you know, what was your gain on that property compared against what you purchased it for, which is something you address with CRA and or other jurisdictions in which you may have taxable income. So I want to just clarify that sometimes they get, you know, combined, but really they're two completely separate layers of taxation. And you do need to address this carefully. And I think in the context of probate planning, the important thing to understand there is what can I do to make sure that I'm not potentially subject to double taxation in any way, shape, or form, because I have two jurisdictions and taxation or probate fees potentially in two jurisdictions to deal with. What you want to avoid is, like, let's say, you know, for example, you only have an Ontario will, and you know that has to be probated in Ontario, and then you also have to go through a secondary, or a representative has to go through a secondary probate process in Florida to actually be able to deal with the real property there. Have you paid, you know, have you paid additional expenses you didn't need to pay? Has there been tax consideration? So, you know, it's a general answer, but it very much depends on the specific circumstances.
I think it's really important, if you have property in different jurisdictions, that you consult with a specialist in each jurisdiction to see how the estate planning can work hand in hand. And if it means having a will in Ontario and having a will in Florida, it's completely a worthwhile process to look into.
Great, thank you. We've only got a few minutes left. Let's see if we can do one or two more. So here's the next question.
And Carrie, sorry, I did want to do one more poll question as well.
Oh, for sure.
So maybe do the question and then we'll do the poll.
Okay, for sure. I guess this will be the last question. Non-spousal transfer of real estate can trigger special registration fees in some provinces. Is it better to hold, let's say, cottage properties in a limited company to avoid land registry costs with ownership held in shares that could be held in joint tenancy?
Okay, I love that question. However, the explanation is going to be a discussion. So I think we need to address that one afterwards, Carrie. Yeah.
Okay. Do you want to try what if there are assets outside of Canada?
Yeah, and I think that was, you know, pretty consistent with what we just discussed, which is, of course, that, you know, you need to consider, do I need a will in that jurisdiction to deal with that one asset specifically? And do, you know, if I have multiple wills, do they work together okay?
Great. Would you like to move on to the poll?
Sure, sure.
Left?
Yeah, I'd love to know how many of you will now revisit your estate plan at this time. So if you could take a minute, we'll wait here while everyone has a quick chance to answer. See what everyone's thinking.
Okay, give it another couple seconds. Okay, here we go. Let's see the results.
Yeah.
Okay, I think we have an overwhelming yes, for sure. 78% of you are considering revisiting your estate plan. Definitely I would encourage you guys to, as you can see on the screen here, we do offer free consultations. You can discuss further with us how we could potentially support you in your estate plan. And definitely, mapping things out carefully. And Sophia as well. It was a pleasure to do this for everyone.